Good afternoon. Welcome to our Law and Geopolitics series. My name is Angela Zhang. I'm the Director of the Center for Chinese Law at the University of Hong Kong. In the last talk, we talked about the Western sanctions on Russia and their impact on China. And in the second talk of this series, we're looking at the legal issues arising from the US delisting of Chinese companies. And I think the law involved here is actually very complicated, if not more complicated than the sanction laws we talked about in the last talk, because it involves laws from multiple jurisdictions, including the Hong Kong and the US securities law, the accounting regulation, as well as the cross-border data transfer issues. And I'm extremely pleased that we have gathered leading experts in this area to talk to us about this topic today. First, we have a securities expert, Fang Liu, a partner from Clifford Chance, and our accounting expert, Professor Paul Gillis from Peking University, and Ms. Luo Yan, a partner from Covington, Berlin. Now, in the interest of time, I will not read out that bio in detail because you came because of them. And we will record today's sessions for those participants who are not able to join us today. I know some of the journalists have expressed interest in joining today's talk, and to the extent that if you want to quote any of the experts today, please contact them individually after this talk to get their clearance. The format of today's talk is that it is as follows. It will only last for an hour. I will start by interviewing each of our three experts here for 15 minutes, and then I will open up the floor for Q&A. So at any time of today's talk, please feel free to put in your questions in the Q&A box. Now, without further ado, let me start by asking questions for Mr. Fang Liu. So could you first start by telling us or giving us an overview of the delisting threat that Chinese companies have faced in the United States? Oh, sure. I guess.
Sorry, did I interrupt?
Yes, I can hear you now.
Okay, good. Yeah, I think thank you, Angela, for inviting us to be here. And it's a wonderful opportunity to talk about this exciting topic. I think the background for sort of the delisting issue posing to the Chinese company listed in US. I think it's fundamentally it's about auditing inspection. Which the PCAOB, which is the regulatory body for all the accounting firms of the listed company, been denied access to the so-called auditing papers by those auditors due to Chinese 1 decade, maybe since the 2003, I think it's almost 2 decades. But until Trump was in office, he acted on it, and with his sort of initiative, the two houses has passed the so-called Holding Foreign Company Accountable Act, which essentially imposing a potential trading prohibition on those US listed Chinese companies' shares if they cannot allow the PCAOB's inspection of their auditing paper, of their auditing firm's auditing paper for consecutively 3 years. And that has become a law last year, and the SEC, which is the counterpart of CSRC in China, and introduced detailed rules and to implement those trading prohibition. I think essentially, which means up to, because that start, the clock is already start ticking, and until 2024, if this issue has been resolved, which essentially means, if not all, substantially all of those US listed Chinese company will be prohibited from being delisted.
Right. I mean, the last time I checked, because the ad keep changing, the last time I checked in this month is that about 23 Chinese companies have been put on the list that might face delisting. So what will happen next to these companies? And how did this oversight board decide which company to target first? And what about those companies that haven't been targeted? Because so far we have over 250 Chinese companies listed in US stock exchanges. So about less than 10% of them have been on the list. So what will happen to the other companies?
It's gonna happen to them very soon. So what the mechanics is, of course, as you may know, there shouldn't be any discrimination, right? when you're enforcing the law. So it's a sweeping across the board changes. So which means whenever which company publish its annual report for past year, it will be designated. So it's the timing of you publishing your report trigger this initial designation to that list. So, but for all of them, sooner or later they will publish the annual reports under the stock changes requirements, right? So it's only a matter of time. Essentially, all of them will be on the list towards end of this month, actually, because in general, everybody has to publish their annual reports towards end of April. So you will see then probably in the last couple of days, you will see substantial all of the rest will be on the list too.
So the market will probably panic, but this is expected.
Exactly.
That there will be a huge list of Chinese companies that will be put on the list. Now you mentioned the holding company, foreign company accountable act, but on the top of that, there is also the accelerating holding foreign company accountable act that the Senate recently passed, although the status is not entirely clear. Is there anything that we need to be alert to this, this new act, and how likely do you think this bill will be ultimately adopted?
I think it's very likely to be adopted because I think both houses, the Congress and the Senate, have adopted similar rule or act, and I think it's just a matter of, in my guess, it's just a matter of months. It's likely to be signed into a law, and the impact of this accelerating holding foreign company act means essentially it will reduce the 3-year grace period we're just talking about under the original holding foreign company act to 2 years. Under the original 3-year regime, the first time for a company to be delisted under this rule is 2024. But when this acceleration comes into effect, it will be essentially bring back to 2023, which means just 1 year from now instead of 2 years from now. So make the issue is more imminent and putting more pressure, I think, on the parties involved.
Right. I mean, so that makes the plan B very, very important as well, because some of the Chinese companies have already saw listed secondary listing in Hong Kong, like Alibaba, JD, NetEase. Now, based on what you have seen, are there any hurdles for US listed Chinese companies to seek secondary listing or even primary listing in Hong Kong? Because I recall some of the tech companies actually initially want to get listed in Hong Kong in the first place, but there are some restrictions in the Hong Kong Stock Exchange. For instance, DD, I recall, wasn't able to get listed in Hong Kong because it wasn't able to fulfill some of the requirements, like it failed to obtain operating license in some of the mainland cities. So it wasn't able to get listed in Hong Kong and cannot satisfy these requirements. So based on what you have seen, what are the legal hurdles for them to see either secondary listing or even primary listing in Hong Kong?
Yeah, actually, what a coincidence, because just earlier today, one of my clients, Zihu, just get listed in Hong Kong Stock Exchange by way of dual primary listing. It was listed last year in the States and finished its dual primary listing in Hong Kong just literally earlier today. So what a coincidence. Actually, I think there are certain eligibility standards adopted by the Hong Kong Stock Exchange in order for them to list those US listed companies in Hong Kong. And originally, there are a couple of things you have to make sure you will satisfy. One is the market cap. It has to be a very sizable company in order for you to get a secondarily listed in Hong Kong. But under the dual primary, which also allow you to list in Hong Kong, I think the bar is lower in terms of market cap requirement. And another potential hurdle is, as you know, for those many high-tech companies, in order for the founder to remain control over the company, they have so-called, weighted voting arrangement or dual class share system, which allow the founder or the holder of such shares casting much more vote than their equity interest. And the Hong Kong Stock Exchange has very particular rules to regulate this type of arrangement. Or for some of those US listed companies, they may not necessarily satisfy those requirements, which could potentially prevent them from being listed in Hong Kong if they don't do anything to change their original weighted voting arrangement. So and also, those two actually more on the legal side. There are also the commercial side, because as you have seen since 10 months ago roughly, there have been huge market sort of not necessarily crash, but the overall valuation of this US listed Chinese company went down quite a bit. For many of them, maybe the 80 or even 90 of their original market cap evaporated, right? So for them, when they come to do another IPO, the valuation could potentially an issue because the sort of I'm worth much more than my current market cap, right? Why would I do it at such a lower valuation? So I think that this commercially could also prevent some of them to do an IPO right now, although alternatively, they can do or achieve an IPO in Hong Kong, not by way of IPO, not offering any new share, not raise funding, but by way of listing by introduction, which means they don't have to do fundraising in this process, so long as they satisfy certain requirements. So.
Right, interesting. Now, I recall that under the Holding Foreign Company Accountable Act, there are a number of disclosure requirements other than the audit requirements, like the disclosure of state ownership, the disclosure of the board's party affiliations, and the disclosure of whether your corporate charter contains mentions have mention of the party or things like that. So do you think if any of this disclosure requirements will pose challenge for Chinese companies listed in the United States, even if assuming they can fulfill the auditing requirements?
I think those rules, although by design it's sort of embarrassing, and because they are for private sector companies, for example, Alibaba, Baidu, they don't have any party affiliation, right? They are not controlled by government. So for them, it's just simply not applicable or nil in their disclosure, right? But it's more an issue for those state-owned companies, which also got listed in the States. There are roughly a handful of state-owned companies also got listed in the New York Stock Exchange. For them, this could be a bit embarrassing, although they can do it, but those type of disclosure will make them look quite awkward. So I think that potentially could be an issue for them, but not for the most of the rest of the companies who are coming from the private sector without any party affiliation or government interest.
Do we know are there similar legal penalty for companies that fail to make this kind of disclosure?
sorry, Angela, the correction was bad.
Yeah, sorry. So is that similar penalty like this listing threat for companies that are not able to make this kind of disclosure of their party affiliation of the boards or ownership control?
Not outright, but I think it's within SEC's discretion. If they consider this is a significant deficiency in your disclosure, then you could potentially implicate your listing status. Although it's unlike the auditing stuff, which is quite straightforward.
Right, I see. Okay, great. So I will come back to you during the Q&A later. And now let me talk to Paul, who's specialized in accounting issues. Actually, have over 3 decades of experience working in an accounting company before he joined Peking University. It's lovely to have you today, Paul, and I'm so grateful that you're here. Now, the standoff between the United States and China regarding the auditing issues have lasted for decades, as Fan Liu have told us. And then also, as he alluded to just now, that it wasn't since the Trump administration that you saw this tension have escalated with the promulgation of the Holding Foreign Company Accountable Act. Now, what do you think is really driving this kind of shift of attitude towards Chinese companies? Because before, it seems the US have been back and forth, but overall it's quite tolerant about this. But all of a sudden they become very serious about these auditing issues. Was it about, the scandal of Luckin Coffee, or is it about the Sino-US tensions? So what do you think?
Well, this whole problem dates back to 20 years ago when there were a series of corporate crises in the United States led by Enron, and that led Congress to pass the Sarbanes-Oxley Act. The Sarbanes-Oxley, among many other things, put in place a regulator for the auditors of publicly listed companies in the United States. That used to be done by the profession itself, similar to the way it used to be done in Hong Kong, and it was found that self-regulation doesn't work. And so they created an independent regulator of the accounting profession, the Public Company Accounting Oversight Board, or the PCAOB. The PCAOB was tasked to do 3 things. It was supposed to inspect, it was supposed to set the rules for how companies are supposed to be audited. It was then to inspect the accounting firms to make sure that they were following those rules. And then third, it was to investigate and punish those who didn't follow the rules. Generally, it's been viewed as the most important function of the PCAOB is the inspections to make sure that companies are following that. They tried to come to China to do inspections, and China said, no, you can't come to China. If allowing a foreign regulator to regulate Chinese companies on Chinese soil would violate China's national sovereignty. And that was a reasonable argument. Plus, they said the working papers might include state secrets that shouldn't be disclosed to foreigners. And other countries took a similar position. In fact, a good share of the world took the position that because of data privacy laws or other rules that they could not allow inspections. The PCAOB negotiated for 20 years with China and the rest of the world, and it's now got the entire world except for China on board to allow inspections. In some cases, those inspections are done jointly with the local regulators, but usually they're done just by the PCAOB. What I think has happened recently was that relations between the United States and China have deteriorated, I think largely because of the rise of China and its increasing competitiveness. Trump certainly started a trade war to try to stop that, and I think that changing sentiment is what led Congress to finally say no. The PCAOB could have stopped this problem back in 2002 when the PCAOB was formed by simply refusing to register accounting firms that it could not inspect, but it thought that was a step too far. That US law firms, regulators, and accounting firms would be upset if they did that, that it was better to allow China to access US markets And that sentiment changed. And so now I think it's viewed much more that this would be better if we actually were independent. And so I think the sentiment changed, and then Congress jumped into the act and did what the PCAOB and the SEC could have done years ago, but didn't have the courage to do.
It's interesting that you mentioned sentiments a couple of times, so it seems more more of the important factor here. Now, I recall last month, Gary Gensler of the SEC expressed doubt that the US and China can reach a deal very quickly. But we did see that earlier this month, China Securities and Exchange Commission, CSRC, have been working very hard and trying to loosen up some of the restrictions. And now, let me ask you a very tough question here. At this point, how likely do you think these two sides will strike a deal? And
well, they've been negotiating for a long time. Go ahead. Sorry, didn't mean to interrupt.
What do you hope for, is the best case scenario here? And if we don't have the best case scenario, what do you think is the worst scenario, and what do you think is or the most likely scenario? Let's go back to my question.
Well, China's been making a lot of positive noises about how it wants a deal and how it wants to retain access to US capital markets. And they've really sounded more upbeat on this thing. I think US regulators threw a little bit of cold water on that, basically because their experience with China was that China would sometimes agree to do something, but then the actual follow through was weak, and they felt that they wouldn't follow through. So I think what's come out of the SEC and the PCAOB is that, yes, they may reach a deal, but that doesn't really solve the problem. Only real inspections that work the way that they're supposed to work will do that. So China may agree. I think they believe China may agree to a deal, but then not live up to it. And in that case, what they're saying is that the first, you basically have to have 3 strikes against you before you get delisted right now under the current law. And if the Accelerating Act comes in, then it's down to 2 strikes. And strike 1 is being issued right now to everybody as they file their annual reports. Then I think if the deal is reached, what they will do sometime late in 2022 or early 2023 is they'll decide whether or not the access has been adequate. And I think COVID may interfere with that. If they decide that access is not adequate, then I think they'll go ahead and give the company strike 2. And then that means they have 1 more year to basically make the inspections effective, or they'll get strike 3 early in 2024 and they'll be delisted. I don't think the Accelerating Act will actually come into effect. I think they'll reach a deal. I think there's about an 80% chance that they'll reach a deal. I think that became a little more complicated after the Russian invasion of Ukraine, which is straining US-China relationships. And I think politically it will be a challenge for the US to agree to a deal. So I think that could form to be an obstacle. I think ultimately, though, the deal is going to have to be done at the top. Now, whether that deal holds for the required 2-year period before the Holding Foreign Companies Act problem goes away is less clear. I think I'd say a 50% chance the deal actually holds, even if a deal is made.
So if we count that there is 80% chance the deal will be struck, and then another 50% chance that if a deal could hold, so there's a less than 50% chance that there will be a real deal, right?
Yeah, I think there's substantial risk right now that we are going to see a financial decoupling, which will start by kicking all Chinese companies off of US exchanges. So I think that is the best case scenario, I think, in the negotiation is that China agrees to allow inspections. China will require, I think, some companies to delist as a result of that. I think one of the real questions is whether or not they will require all state-owned enterprises to delist. Before, when they were trying some trial inspections a few years back, The CSRC asked all the other regulators in China if there were any companies that ought to be off limits. And they basically found that every regulator found that there were companies that they wanted to keep off limits. For example, the state asset regulator wanted to keep all state-owned enterprises off the list. And the internet regulator wanted to keep all the internet companies off the list. And basically there was nothing left by the time they got done. So I think this ultimately may require intervention at a fairly high level in China to reach a deal, telling them that they want to have a deal reached and we can't withhold everything. However, I think there are companies like Didi that'll be viewed as too sensitive to be listed overseas, and those companies will be required to delist or dispose of certain operations that are considered to be too sensitive to be listed.
Right. Now let's get to the fundamental here, Paul. So do you think that allowing the inspection of these Chinese companies can really address the US audit concerns about these Chinese companies? Do you think it can really improve the quality of the audits of these companies? And by, like making these Chinese companies to make so much disclosure of their state ownership, party affiliation of the board members, and etc. Do you think it will actually work to help protect US investors? Or do you think that the US regulators are barking up the wrong tree here?
Well, the argument is that doing inspections of auditors will improve the quality of audits and thereby improve the reliability of financial statements of US listed Chinese companies. I don't think it will do that. I think that the accounting firms are currently following the rules as best they can. And most of the audits, particularly of all the large cap companies, are done by the Chinese affiliates of the big four firms. And I know that they are trying very carefully to comply with the rules. I believe they do comply with the rules. They have internal inspections, which mimic a PCOB inspection. And from all in evidence, those internal inspections are quite rigorous. I think actually this thing could backfire a little bit. And that is because the PCOB requires that partners who are involved in deficient audits, and the PCOB has historically found about 50% of audits to be deficient. When they find a partner's involved in a deficient audit, they insist that the accounting firm punish the partner. And that usually is a financial penalty, which can be fairly significant. And I think that partners are going to become aware of that, and that may make them more conservative. And that is, they may try to avoid taking any kind of position that could be criticized. That's not necessarily good for financial reporting, because companies may learn that disclosing more information to auditors creates more problems than it solves. And audits are based on an open dialogue between the company and the auditor. And so if you get in the way of that, the audit quality could actually go down. I think there's a risk of that.
Well, this is a very important point, Paul. I mean, because it seems like they're not achieving what they're supposed to achieve, and create a lot of problems ahead, and it might actually backfire. Now,
well, they're saying that Luckin Coffee, for example, was a good example of something that this could have prevented. I don't believe it could have. Luckin Coffee, I believe their audit was done in accordance with the PCOB audit standards. And in fact, the auditor, who's since been fired, was a big four firm that claims it actually found the fraud in its audit. And so the audit was working exactly the way it was supposed to work. Now, if their evidence comes out that they missed it in earlier years because they didn't do an effective audit, that will be a different story, but there's been no evidence of that so far.
Right, interesting. So the Wall Street Journal recently has a scoop that some US listed Chinese companies were able to get around this auditing threat by hiring a US auditor as an alternative approach. Do you think that that solution worked for most of the companies, Chinese companies listed in the United States, or are there any limits to this approach?
I don't think that approach works for most companies. There have been two companies that have announced that they have changed from their principal auditor, the auditor that signs the audit report, from the Chinese member firm of the Big Four firm to a U.S. member firm of the Big Four firm. That was possible, I think, in both of those cases. They were both biotech companies. They both had significant operations in the United States. Now, under the auditing rules, if an auditor is to sign off as the principal auditor on an account, to sign an account, they must do the plurality of the work. They have to do more work than anybody else. And if they rely on their Chinese member, they can rely on their Chinese member firm to do some of the work. And the PCAOB this week punished a couple of local firms in the United States that were basically signing off on work done by a Chinese firm without actually taking responsibility for it. And they were basically fined and banned from practice. And so I think in most cases you can't do that. Plus, if a US-based accounting firm wants to sign off on the audit of a US-listed Chinese company, it's usually going to have to come to China. And if an auditor wants to come to China to do work, it has to get a temporary audit license from the Chinese Ministry of Finance. And that obtaining that license will also require them to comply with Chinese laws, including leaving their audit work papers in China, so that they cannot be and not turning them over to a foreign regulator. If they follow that rule, then the PCAOB may well put that U.S. firm on the list of firms that can't inspect, and that would jeopardize their entire client base. So I think most firms are going to be very reluctant to do that. So I think the cases we've seen so far have somewhat unique facts. They have big offices in the United States, as some of the biotech companies do. They do a lot of their research in the U.S. In order to comply with FDA requirements. And so I think we may not see very many of those. You certainly couldn't audit an Alibaba or a Baidu from the U.S.
Right, understand. Thank you, Paul. And this is really, really helpful. I'll bring you back later. So now let me move on to Luo Yan to talk to us about the cross-border data transfer issues, because particularly in the past 18 months, China promulgated a lot of data-related laws. We have the personal information protection law, data security law, as well as a bunch of data regulations. Now there's too much for us to outline here, but I wonder if you can, in a couple of minutes, this is really hard, in a couple of minutes outline to us, the relevant laws, particularly the law that relates to the topic that we're discussing here.
Sure. Thanks for having me here, Angela. I think as exactly as you mentioned, that this is usually not our crowd of audience, because we usually don't get to talk to capital market folks because what we do is more sort of nerdy stuff on cybersecurity and privacy. But especially with the that cybersecurity or data security certainly pops up in the capital market world, which is pretty unusual. But I wanted to just clarify that, because it gets much more complicated when we look at this. I just wanted to sort of set up a little bit background, as you mentioned, before we dive into what we are talking about, really relevant to the topic. So as you mentioned, China now has a sort of a three-pillared data security related regulatory framework. So we have the cybersecurity law, which was passed in 2016 and then took effect in 2017, and then we have the data security law was promulgated last year and took effect in August last year, and then we finally have the personal information protection law that took effect in at November last year. So there's a framework of data related rules. Usually those rules are, because they are cross sector, and also it's very high level. So it's really hard to see, how that gonna impact our sort of specific scenario of listing and listing and delisting overseas. But we can get to that but at least from this framework of sort of general data transfer rules, we can see that there will be rules in place to somehow restrict the flow of personal information out of China. So first of all, think about the transfer of personal information. It's not prohibited per se, but it will be rules to regulate that kind of flow. And the second part, which is probably more or less sort of unique to China, is a regulation related to the flow of quote unquote important data, or some translated as critical data. However we translate it, it really means that data that is important for Chinese national security purpose, right? So this is really, if you look around in other jurisdictions, Europe has quite similar privacy rules as we understood, and you probably see it on the news that there's always been question on how data can, personal information can flow between like the United States and European Union, but we're not. But those are sort of only on the private, personal information side. For China, there's also going to be a restriction on the important data, which a lot of them could be non-personal data, could be some operational data for, as the professor mentioned, some of the sensitive companies that operate in the sensitive sector, that some of the data they generated, even for their operation, for the business, could fall into that scope. So that is sort of, as a cross-sector level that those cross-border data transfer rules might restrict that kind of flow. So when we get to the listing versus delisting, this world, it gets a little bit more complicated, because that's a sort of two separate regulatory regime that when they come up to, when they was designed, it's not necessarily that they're talking to each other and coordinate with each other. So you will see some of the concept that is doesn't necessarily match, or some of the regulations mention one thing, but they, something else, comes up, so there are other rules comes up. So I wanted to mention two particular things, which you probably get to your next question as well, but I just wanted to sort of, help the audience think a little bit. So before listing in any of the stock exchange outside of China, that may or may not include Hong Kong, which is subject to debate. But at least in New York, for sure, any U.S. stock exchanges under the cybersecurity review regulation, which was updated earlier this year, they those companies with more than 1 million users will have to go through the cybersecurity review. So this is not directly related to the audit or the inspection issue that we talked about. It is sort of pre-listing and the regulatory approval before you even get to the market. DD was subject to this precisely. That's what DD's investigation was about. And for that investigation, the criteria or the focus is really on the transfer of important data or any of those information that has been disclosed in the process of listing. So that's one thing, that's even before you're listed. And then there's obviously the second part will probably be that with the listing and auditing requirements, on-site auditing requirements, where CSRC just issued a new regulation to say how you can, essentially how you should handle or transfer the working documents or any of those accompanied materials, how you should handle that. But I just wanted to mention that this new CSRC rules actually did not mention important data and it made a very vague reference to data security, but not mentioning any of the specific mechanisms that even the cybersecurity review that I just talked about hasn't been mentioned in that. Instead, it revert to the old concept of state secrets, which again is something that is sort of developed pre all the data stage world, that the law of the state secrets, and that's sort of the dimension that the CSRC rules is making. So as I mentioned, like there's not necessarily a coordination between those type of rules. I'll stop here because I can see that there's other questions. Yeah.
Look, I mean, there's a lot to unpack here. Let me do it a bit by bit. So first, you talk about the DD's case. So for audience who are not familiar with this case, so last July, DD made a debut in New York Stock Exchange, and 2 days after its listing, the Cyberspace Administration of China announced that the company was subject to a cybersecurity review, and that was quite a shock to the market at that time, because the cybersecurity review regime was kind of established a year ago with sort of an obscure regulation, but no one was paying too much attention at that time. And all of a sudden, with the DD case, it attracted so much attention, and people not only worry about the companies that are thinking about listing in the U.S. or in Hong Kong, which is still, as you mentioned, a subject of debate whether they need to go through this review. But what about those companies that are already listed there, right? I mean, there are more than 200 Chinese companies listed in the U.S. stock exchange. I mean, do these companies also need to go through cybersecurity review now, especially after this DD case, because it's been quite a few months? Have you seen any of these companies now applying for cybersecurity review just to preemptively address this problem?
We don't have that information, so it's not as you mentioned, that's not explicitly required by the rules. So we don't have that information to say that other companies also have to go through a cybersecurity review. But I like to just mention a little bit, because the background of the cybersecurity review measures, because when it was first promulgated, it was really meant to address the supply chain security issue. So just thinking about if you're a nuclear power plant, you wanted to buy some software, then you wanted to have a CFIUS type of review to see who your suppliers is and how secure their product is, or any backdoor or things like that. So that was the purpose at the time that when it was first promulgated. But obviously, with this latest draft, it adds the requirement for any of the platform companies with over 1 million users to go through it before they can listings in the foreign markets. But that's not so. The scope of this review is still pretty narrow, in the sense that it's very specific, that it's triggered by a plan to list outside of China. And also by this kind of company with more than 1 million users. So other types of the actions, including the on-site audit or anything else, whether that will be subject to this rule, it's still not quite clear. Maybe unlikely, but that's up to the regulator to decide. Yeah.
Right. Am I right that on top of the cybersecurity review, there is another layer called data security review? I know that, as Fang Liu told us, that the Holding Foreign Company Accountable Act requires companies not only to provide audit access, but also to make a lot of disclosure, the state ownership control, it's also quite politically sensitive, right? I mean, and the party affiliation of its board members and things like that. Now, does those type of information need to go through the so-called data security review? And what exactly is this data security review?
That's a great question. So the data security law provided that there's a data security regime. So it's really discussing about activities that are, again, impacting China's national security. So, but there's no implementation rules yet. There's no designated agency on that yet. So it's not an operational regime yet. Unlike the cybersecurity law, the cybersecurity review, which has a pretty clear process, has a top regulator. And has a specific regulator in mind, and also has a mechanism to go through it. So the data security review is not operational yet. But as I mentioned, that there's a broader concept of important data that is out there. So some of the data, and with that important data or critical data, the distinction or the difference between information versus data is actually pretty blurred. So if for at least for us, in the cyber or privacy world, we think as data as different from information. But with the important data concept, it's probably going to be the same. Sensitive information or critical data. So that could be what ultimately comes out in practice. And with that, the transfer of any critical information outside of China, maybe not just in this context, but this context could be included, is going to be restricted. So there will be something that is in place to restrict the transfer of such data.
Well, I mean, to follow on that questions, now with regard to this type of cross-border data transfer, do we have any clarity regarding, who should I approach as a company? Which regulator should I approach to ask for approval? I recall the securities regulation appears to have a provision that you need to obtain the CSRC or securities regulator approval, but China has so many data law, and also the sector regulators and the data regulator have their own regulations. So do we know, is there a precise procedure company need to follow? Who should they approach and ask for what kind of approval?
The short answer is no, that there's no sort of precise coordination mechanisms among the regulators. And also, as I mentioned, that some of the regulations themselves are not compatible yet. So there's no procedural rules. But I just wanted to mention that even for the general regulatory regime of critical data or important data, the rules are mostly sort of decided by the sectorial regulator, right? So we see that in terms of the transfer of certain, some very specialized data, like in the clinical trial, context, that when you transfer genetic data, then there's a special regulator for that. So it's still at the early stage that whether CAC or other sort of horizontal regulators in the data space will let the sectoral regulator to lead the way in terms of cyber or data issues in this scenario. But that's a possibility that ultimately companies can approach to CSRC to discuss those questions. But again, CAC is another important regulator, especially for companies who are not in terms of delisting, but sort of wanting to list or somewhere, or wanting to list in Hong Kong, in US, or any other markets outside of China. So because of the cybersecurity review, we do see companies actually do pre-consultation with CAC on those issues.
Right, I see. So I know we have only about 10 minutes left, but I really want to get to the last question with you. And at this point, I also want to remind the audience, if you have any questions, feel free to leave in your chat box. Now, the question I have for you, Luoyan, is regard to a report I recently read, an analyst report saying, which is, I think it's a very important point, saying that, look, I mean, despite the fact that CSRC is working hard to try to accommodate the US requirement, however, he doubts that there is a possibility for the Chinese law to accommodate that, because what he was saying is that the US requirement is actually asking China to give a jurisdictional wide access space, whereas what the CSRC is doing here is to kind of do a case-by-case access space. So it seems like the two sides are not, are talking on the same level here. Now, from what you have seen from China's data law, do you think China have the wiggle room and the leeway to accommodate the U.S. requirement for jurisdictional wide access to the audits? And Paul mentioned earlier that there a lot of countries initially have this problem with the U.S. However, they were able to negotiate and reach a deal. For instance, European countries have a lot of concern about U.S. data and privacy law, and I saw they enter into cooperation agreement with the SEC, and along with, which is accompanied with a data cooperation agreement. So I wonder, given our current legal framework, is there a possibility for us to reach a deal to allow US a jurisdictional-wide access to the data?
Well, that's a great question. I think the current Chinese law, for example, both the data security law and PIPL actually have provisions to say that if a company wants to provide data stored in China to a foreign judicial or enforcement agencies, they have to get approval from the Chinese government. So the system or the framework is designed to potentially allow certain data or information to be transferred with the approval from the Chinese government. So it will really depend on how this can be whether a sort of a negotiation can reach the results that both parties are satisfied, and there's a established channel for such information to go through. But I do want to mention that something we also see in other sectors, that even certain transfer of data or disclose of information can sort of, has an established channel to go through. You always find that you have other information that are not squarely fitting to those narrow scope of what has been negotiated channels. So I guess that's what they call it as unfatted access or the jurisdiction-wide access, and that's not going to happen. So what the Chinese law probably will be able to allow is for negotiated set of data or information to go through certain channels, approval channels, and then has a bilateral mechanism to let the data go through. But ultimately, companies probably still going to find that there's a lot of the other data that couldn't fit into that narrow scope. Yeah.
Right, I see. Okay, thank you so much, Luo Yan. So at this point, I would like to bring back all three panelists to the discussion with our audience. We have received a number of questions already, and I saw Paul has very kindly answered most of them. Well done, Paul. And so let me tackle the remaining question here. First question from Brian. So Brian Hand, I believe is my colleague. Would love to hear Fang Liu's comments and thoughts on how attractive alternative dual secondary introduction listing in Shanghai and Shenzhen for those US listed entities, given some of the challenges of moving to Hong Kong at the moment.
Yeah, thank you, Brian. Okay, long time no see. Oh, well, I didn't see you. Okay. Yeah, I think that's something has been explored by the Chinese regulator for years. As you may recall, back at the time, the Xiaomi started its listing in Hong Kong. It's also actually contemplating a dual listing in China via so-called Chinese deposit receipt. That was, subsequently aborted, and only the Hong Kong IPO went through. I think that has always been been considered by the Chinese authority. Although the bar is quite high, and originally it requires only those U.S. listed Chinese company which has the market cap of no less than 200 billion RMB in market cap, which I think, which essentially means roughly 30 billion in USD dollars. And it's essentially screen out substantial majority of those USD Chinese companies, probably only 10 may qualify for that. And so I think that's it's probably single largest obstacle for this route. And even for those qualified, I understand they have made some efforts, some initial efforts or attempt to be listed in China, but given some complex factors and in the back, and all of them actually abandoned eventually. But with this U.S. further prohibition approaching, and I think this topic may be revived, I think, and maybe sort of seriously reconsidered again, although there's certainly need to lower the bar and make it a much easier route.
Right, I see. Well, we have received Brian actually have a follow-up question to Luo Yan. When do you think it will determine if Hong Kong will be an onshore, offshore listing for cybersecurity and data security? And what would you guess?
Well, I think that right now the rule is still that it's not always necessary to seek a cybersecurity review for the Hong Kong listing. So CSE has discretion on that. I think Feng Liu's, I read from the news that Zhihu didn't go through that process, and I know some others did not. So that's the first fact. But it's possible that they may be subject to it. And the second question is whether that will be whether that when that will be determined sort of like an adequate or like like a jurisdiction that don't need additional security scrutiny. I think that will probably be decided really more from a national security perspective rather than a sort of privacy consideration. So it's not it's not going to be decided by what Hong Kong's privacy rules are. So I hope this is the right, yeah.
Right. I mean, this is a really difficult question. I saw Paul has been very kind to answer all the questions for him, but I do want to bring up this question he already trying to answer because I think it's important. What are the commercial considerations for Chinese company listed in the US choosing between a secondary listing in Hong Kong and a dual and a primary listing in both markets, Paul?
Well, I think the advantage of a listing in Hong Kong, the dual primary listing, the primary advantage seems to be that you can trade the shares on the Connect, which means that Chinese investors can invest in those companies. That's been one of the problems with the companies that list in the United States. If you want to buy shares in Alibaba before it got a dual listing or before it gets a dual primary listing, you basically have to have foreign currency to buy that. And Chinese are quite severely restricted in terms of how much foreign currency they can get, generally $50,000 a year, which is not much when you're talking about investments in some of these, some of China's most successful companies. So I think there's an advantage to a dual primary listing. It also probably facilitates getting yourself listed in, moving it to your sole primary listing. One of the differences between a dual primary listing and a secondary listing is for a dual primary listing, you have to comply with all of the rules of the Hong Kong Stock Exchange, including all of their document requirements. The secondary listings are using their US documents, including US GAAP financial statements, to do the listings in Hong Kong. And it's not that difficult to convert those US documents into documents acceptable in Hong Kong, but it will make the accounting firms and the law firms rich in the process.
Thank you, Paul. We are exactly on time. And I'm extremely grateful to our three experts here for spending an hour with us in answering all these really extremely complicated questions. I learned a great deal. And although there's still a lot of uncertainties ahead of us, but I do think that today's talk is particularly enlightening. And it does help me, at least personally,